The characterization of property as either separate or community is most often discussed in the end of marriage context. But characterization also impacts each spouse's right to manage and control property during marriage. If property is one spouse's separate property, then the other spouse has no right to manage or control the property. But if property is community property, then spouses share rights to manage and control the property during marriage. In this video, we'll focus on the implications of shared management and control in relation to community personal property. Recall that personal property is movable or intangible property. It includes assets such as furniture, clothing, cash, and bank accounts. The family code states that each spouse has an equal right to manage and control community personal property to the same extent the spouse could manage and control the property if it were that spouse's separate property. Consequently, during marriage, the general rule is that either spouse may make decisions regarding community personal property, including decisions about use, expenditure, and transfer. For example, if a wife wants to use community property wages to purchase an expensive designer bag, she is entitled to do so. From a legal perspective, she doesn't need her husband's prior consent to use the community funds. The family code does, however, place some boundaries on transfers of community personal property to third parties to prevent one spouse from depleting community assets to the other spouse's detriment. If one spouse wants to gift community personal property to a third party, then the spouse must first obtain the other spouse's written consent,